Okay, where we left off was at the end of item 7, coming into item 8, which refers to conditional cost agreements, which are in effect no win, no fee cost agreements. These cost agreements I find the easiest to tear apart because they're closely governed by the Legal Profession Act over the course of a few sections, not very many sections I might say, but those of you that do use conditional cost agreements will be well aware that you can make reference or charge an uplift fee, and under the Act you can charge an uplift fee of up to 25%. I don't know if the words up to 25% in some of your minds means actually 25%, but to my mind, up to 25% means anywhere between 0 and 25%. So in your conditional cost agreements, you are required to provide a range of estimates of the uplift fee. A range of estimates of the uplift fee, not just saying we can charge or we will charge an uplift fee of 25%. And you are also obliged to set out in the cost agreement the variables which will affect the uplift fee. The explanation, there should be an explanation of the major variables that will affect the uplift fee, which may be up to 25%. The sensible lawyers will often say, we will charge an uplift fee of, or we're entitled to charge an uplift fee of up to 25%. However, for this matter, for these reasons, bang, 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 we will charge an uplift fee of 20%. However, for these other reasons, bang, 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 we may increase our uplift fee to 25%, but we will let you know beforehand, etc., etc., etc. The uplift fee is calculated on the basis of the X percentage of our professional costs, excluding disbursements, excluding GST, so on and so forth. Those sensible solicitors usually get paid their uplift fee. But the solicitors that just simply say, we will charge an uplift fee of 25%, thank you very much, full stop, find that it is extracted from them if they've been paid that amount, or if they've not been paid that amount at the time of review, that they're not entitled to recover any uplift fee at all. So, if you go through those first 3 dot points, that's what I'm getting at. If you then go to the 4th dot point in section 8, you'll see that, or those of you that use conditional cost agreements, that they no win, no fee is based on success. Now, you don't say in your conditional cost agreements, we will charge an uplift fee, or we will charge our costs to you if your matter is successful, full stop. You have to actually define what success is, and not only do you need to define success, but you actually have to say or state that you have a belief that this matter will be successful. So you have to state the belief of your allegation, so to speak, or your hope of success. Now, when you state a belief, you have to give some sort of reason, I would have thought. That's what the cost judge seems to think. You don't just say, we think you'll be successful, or we believe that this matter will be successful, especially when you've just sent the conditional cost agreement out on day 2 of receiving instructions in respect of a matter that you know is going to run for 3 years. So you have to try and give some sort of evaluation of your belief in the success, and importantly, and I mention this later on, excuse me, you have an obligation to update your belief in that success. You have an obligation to update estimated costs and so on. Again, surprisingly, this enables me, this next bullet point, no mention of statutory 5-day cooling off period. I used to write submissions of, 2 or 3 or 4 pages in fine print of why somebody's conditional cost agreement should be torn up and put in the bin. Now I just look to see if there's the statutory 5-day business cooling off period mentioned, and if it's not mentioned, my submissions are about half a page. So as long as you keep leaving that out, that makes my life easier when I want to tear up your cost agreement. So please be aware that the relevant sub-paragraph that I've referred to there requires you to have specific reference to the statutory 5 business day cooling off period. In fact, it's 5 clear business day cooling off period. Similarly, the next bullet point for conditional cost agreements is that you must ensure that the client has been informed in writing of his or her right to obtain independent legal advice. That's another deadly oversight where we can quickly put the cost agreement in the bin. And finally, the point that I referred to earlier this morning, or the first half of this seminar, although cost agreements generally do not need to be signed by the relevant payer, provided they can be accepted by conduct, that does not apply to conditional cost agreements. Conditional cost agreements must be signed by the relevant paying person or on behalf of the relevant paying entity. So most of Section 8 in my paper, in fact all of Section 8 in my paper, focuses on conditional cost agreements in that manner, and I strongly urge you, notwithstanding my paper, to just flick through the relevant sub-paragraphs and subsections of the Act itself. Section 9 of my paper, or item 9 of my paper, this ought to be fairly self-evident. If you make any attempt to oust the client's right to a cost review, when I say cost review, I mean a taxation of costs, a review of costs in the ordinary course. If you have any provision in there that purports to preclude a client's right from seeking a cost review, that automatically invalidates any cost agreement in which that provision appears. I haven't seen it too often, I must admit, but I have seen it maybe once or twice. Point 10. The cost agreement should be in clear, plain language, not too circuitous, convoluted, lengthy, etc. From my experience, most cost agreements are not particularly lengthy or convoluted, to be fair. The conditional cost agreements and no-win, no-fee agreements do tend to stray into that territory. They can be quite lengthy. I had one recently where I think the conditional cost agreement was in the vicinity of 38 pages long. It included 5 schedules and also had attached to it a full copy of the Supreme Court scale of costs. I tried to get some sense out of that cost agreement, tried to work out how the schedules fitted together with the body of the document, tried to work out how the reference to the Supreme Court scale in the cost agreement made any sense at all, because although the cost agreement did refer to the Supreme Court scale, which is why I guess the tea lady stapled a copy of the scale to it, it didn't otherwise adopt the scale in any way, shape or form. Not quite sure why the scale was there. So anyway, the relevant firm of solicitors went to that effort of pumping out a 38-page document. I went to the effort, probably spent 2 to 3 hours trying to work out what it meant. Now, if I, as presumably a reasonably competent barrister, could not work out what that cost agreement meant, how on earth could the client be expected to understand it? This was one of the matters where the relevant firm got burnt to the extent of $37,000 because of this hopeless cost agreement. It was probably the most ridiculous cost agreement I've ever seen to date. In any event, I'm expecting that you have cost agreements which are sensibly drafted, clear plain language, understandable, etc. Point 11. I have always maintained that a solicitor's cost disclosure statement should be separate, should be a separate document. It is, as I said earlier this morning, it is a document you must produce whether you have a cost agreement or not. A lot of cost agreements, for reasons which puzzle me, and I'm not quite sure why or where the template came from, because they do read from firm to firm, they do seem to read the same. Those cost agreements say that the cost disclosure statement forms part of the cost agreement, that the terms of the cost disclosure statement are part of the cost agreement. So that helps me tear up cost agreements, because if your cost disclosure statement is faulty, then your cost agreement is faulty because you have cross-referenced it and adopted it as part of your cost agreement. Now, I don't want to spend too much time this morning. It's not the purpose of the paper to take you chapter and verse through all the requirements of cost disclosure, which are quite extensive in the Act from 3.4.9 onwards. But if you do merge the documents together, so to speak, so they are one agreement, then the faults in the disclosure statement will become faults in the cost agreement. And as I've said there, can adversely impact on the integrity of the cost agreement in any event. There's also the issue that even if you have a cost disclosure statement which is not part of your cost agreement, even if you do have it totally separate, if you have failed to comply with costs disclosure, that gives the tribunal the opportunity, or gives your client the opportunity to apply to VCAT, the tribunal, to have your cost agreement set aside. So non-compliant cost disclosure can impact on your cost agreement. Non-compliant cost disclosure, set aside cost agreement in VCAT. Non-compliant cost disclosure in the cost court. The cost court will not set aside your cost agreement because it doesn't have jurisdiction, but it has power to ignore it instead. So non-compliant cost disclosure will one way or another destroy or adversely impact on the integrity of your cost agreement. So whether you join the documents together, disclosure and cost agreement together or not, if you are non-compliant on one side of the fence, it will virtually destroy your compliance on the other side of the fence. As to disclosure, and as I said before, the purpose of this paper is not to take you chapter and verse through disclosure requirements. They go on forever. But it does give me a segue into point 12, where all too often we have these ambiguous or insufficient cost estimates. Now, your cost estimates, as I said before, they do not have to be in the cost agreement, but they certainly have to be in the cost disclosure statement. And I've come across now a few times where solicitors have, we estimate our legal cost to be, as I've said here, $2,000 to $95,000. I mean, that's just bloody ludicrous, quite frankly. The cost judge thinks so. The judicial registrar thinks so. What information is that properly giving to a client? $2,000 to $95,000. And then to make matters worse, I see some cost estimates saying things like $2,000 to $95,000 or more. So I've even had two cases, one in the magistrates court, where what does or more mean? Does that mean it's an estimate or it's not an estimate any longer? If it's an open-ended estimate, then it's not a range, and it has to be a range of estimates. So if you start sprinkling, because you're a bit nervous about your cost estimates, if you start sprinkling phrases like or more, or it could be in excess of, or we think it's greater than, or it could be, or whatever, then you are actually making things worse for yourself. So try and give sensible, informative cost estimates. In a perfect world, I would suggest, for instance, that you might say work from A to up to, say, mediation or whatever. Professional costs could range from, I don't know, $30,000 to $45,000. If it's no win, no fee, you might say, therefore, the uplift, let's say it's a 20% uplift, not a 25% uplift. You might then say the range of the uplift fees X to Y. You might then say the GST is A to B. You might then say the disbursements are whatever to whatever, and so on and so forth. I've seen some excellent cost estimates from some firms, and one particular firm in the country provides fantastic estimates of disbursements, for example, on expert reports and all sorts of things, medical reports and so on. So try and at least be sensible. I'm not saying go overboard with it, but don't just say our costs will be from $2,000 to $95,000 or more. Point 13, which I've already touched upon. As I said before, the cost court, strangely, I'm not sure what the philosophy of the Act is, strangely the cost court does not have jurisdiction to set aside a cost agreement. VCAT has that jurisdiction, but section 3.4.44 capital A of the Act, in a sense or in effect, gives the cost court the opportunity to turn a blind eye to the cost agreement, to ignore the cost agreement or the rates in the cost agreement if you do not have appropriate cost disclosure, etc., etc. So even if you draw a bill or produce an itemised bill drawn on your cost agreement rates, and your cost agreement is found to be deficient in some way because of cost disclosure, then the cost court can still tax your bill, but will apply the relevant court rate, court scale, or the PRO, or whatever as the case may be. Or worse for you, will tear your bill up and tell you to redraw another itemised bill on the correct scale or PRO, which is going to cost you another $10,000. So the first $10,000 of your bill was wasted. Bearing in mind that cost consultants generally charge about 10% of whatever the professional costs are that you're seeking to have reviewed. Now, some of you may know that there's a new Act on the horizon. It's already in existence. I've referred to it there right down the bottom in Roman 8. Be aware of the forthcoming operation of the legal profession uniform law, which is hidden as Schedule 1 to the Legal Profession Uniform Law Application Act 2014. You probably will have been receiving alerts from the Legal Services Board as to the commencement or operation of that Act. It's not yet operative. I'm not sure. I think it might be hopefully coming in around about January, February of next year, but correct me if I'm wrong. But if you do take the time to, for argument's sake, click onto OSLI and go and look up the Application Act and then go to Schedule 1 to look up the Legal Profession Uniform Law, the actual uniform law is not unlike this as Schedule 1 to the Act, perhaps not quite as thick. But if you then go to Part 4.3 of the uniform law, that really contains the guts of what I've been talking about this morning, which is currently in the LPA. So if you go to roughly from section 174 of the uniform law, that tells you all about costs disclosure, not too dissimilar to what we have at the moment. And if you go to section 179, there's about 6 or 7 sections there which tells you about cost agreements, not too dissimilar to what we're talking about this morning. But it's worth just stopping for a petrol fill up at section 178, which says that any non-compliant cost disclosure will automatically void your cost agreement. So if you do not comply with cost disclosure, it will automatically void your cost agreement. No need to go to VCAT, no need to do all sorts of things. It's nice and easy now, so I'm just going to get a bigger rubbish bin to put cost agreements in. And so I would implore you to read those sections when you get a chance. Section 178 of the Legal Profession Uniform Law, which is, as I said, found within the Act, the Legal Profession Uniform Law Application Act 2014. I have nothing more to say unless you want to ask me some questions. Okay, the question was, how does cost disclosure apply to barristers? I think that was the gist of the question, was it? Well, it applies to barristers as well. Barristers don't have to give as much information about cost disclosure because when I say we, me being a barrister, we provide that information to you, the solicitor, to pass on to your client. So we are obliged to, for instance, give an estimate or give a disclosure of our fee rates. We have to give disclosure of our estimated fees, just like you have to give disclosure of estimated legal costs for a particular block of work, etc., etc. We have to give disclosure of how often we will bill, just like you will have to pass on to the client. So that's the gist of what we provide to the solicitor, and then the solicitor blends that in to the full disclosure requirement that you as a solicitor have to give to the client. So we're not off the hook, and all of my tax invoices that go through my clerk, Michael Green here, we have the same delightful invitation to complain on ours as you on yours. So there's no real difference in practice. The question was, if a cost agreement goes out from the solicitor and let's say barrister's briefed, I don't know, 6 months later or whatever, and then we as a barrister, provide our cost agreement, what do you do? Is that the gist of the question? The answer is quite simple. You as solicitors are obliged to give ongoing cost disclosure no matter what. So just because you might give initial cost disclosure, say in day 2 of your retainer or day 7 of your retainer, do not think that, oh, thank God that's out of the way, I can just get on with doing work for the client. And so your initial cost disclosure estimates might have predicted fees of up to $50,000. And then 3 years later, you've discovered that you've rendered fees for $435,000. You have to keep giving ongoing cost disclosure, and if, as often occurs, you start bringing in barristers down the track, then you are obliged to get as I've said before, a fee estimate and so on and so forth from the barrister, and then you pass it on to the client. At that point, you don't have to keep getting them to sign or re-sign cost agreements. You just pass that information on with a very cleverly, thoroughly worded letter that you can produce to the cost court as evidence that you in fact did that. Because when we're in the cost court, we're going through your file like a fine-tooth comb. So even if you get an estimate of a fee estimate from a barrister, the court will want to know that you've definitely passed it on to the client, not just stuck it on the file on a spike and closed the file up. But you don't need to keep getting cost agreements re-signed as such, unless you're entering into completely different rates, completely different arrangement and so on, or a completely different matter.
Thank you very much for coming, and thank you very much to Peter particularly for such a comprehensive and enlightening exposition on cost. Please join me in thanking Peter Lovell.